Welcome back to Real Conversations with Johnnie Finch. Back by popular demand, I have civil rights attorney Harry Daniels. Unfortunately, we're back again, but fortunately, we get to hear from Mr. Daniels. Listen, on Real Conversations, it's experts only, man. I get so tired of going online and reading commentary of different people talking about people who are not qualified to talk on these subjects. So if you come here to Real Conversations, you only get experts. Obviously, we've had another incident this past weekend. Mr. Rayshard Brooks was shot by law enforcement, and so I brought Attorney Daniels in just to speak a little bit about that, his reactions to the video, and what he sees legally. How you doing, Attorney?
Hey, I'm doing well, Johnny. What's up? What's going
Man,
on, man? I'm glad to see you, but unfortunately, on these circumstances, but I'm glad to see you though, nonetheless.
yes, sir. Tell me what you think about the Mr. Brooks video.
Oh man, my reaction to the Mr. Brooks video is one, and let me start by saying this: this happened in my backyard.
Come on.
This happened in Atlanta, Georgia. My law office is downtown Atlanta. Uh, Atlanta Police Department. I know exactly where this transpired. I know the Wendy's. In fact, I've been to that Wendy's. So I know exactly what happened at. What I saw in the video was a beginning start at the start of it was a simple, um, reason suspicion or DUI stop. An officer asked questions consisting if anybody ever represented anybody or even had a DUI, been involved with DUI. Consistent questions about how many alcohol beverages have you had that night or whatever? When the last time you drank? Uh, where you coming from? Standard questions, and they ask you to blow in a what we call a breath alkalizer to determine the presence of alcohol, and a standard roadside breath test to see if a person in fact have a blood alcohol concentration at a certain number, and Georgia is 0.08. You can't be higher than 0.08 to legally operate a vehicle in the state of Georgia. And in fact, if you are violating a traffic offense coupled with the presence of alcohol, you actually can be charged with DUI, less safe. I know North Carolina they call it DWI, but some variation of the same type of law. I'm sure you know that as well, Ms. Finch, being a criminal defense lawyer. But standard video, I mean, field sobriety questions. The officer involved, both with officers involved, they decided to effectuate a arrest for drinking and driving. Now, a lot of people ask, well, why couldn't they just drive him home or let him sleep it off and things of that capacity? Well, that's up to officers' discretion. But if the officers would have let him drive home, and he subsequently caused an accident and killed somebody, that officer being liable as well as probably the city of Atlanta being responsible for that as well. For as an officer driving him home, I know they probably used to do that back in the day. The neighborhood or the town guy, who drinks, and the officer may give him a ride home, or whatever. But in this day and age, these officers, they a lot of times they follow the book standard, and as such, if they find somebody that's who is violating the Georgia laws as it comes to drinking and driving, or the driving less safe, more likely than not, they're going to make an arrest. Majority of the time, they make an arrest. They don't just give a citation. They're going to arrest you and take you in. And that's what happened in this situation. I think that Mr. Brooks, I think that no bias is needed from the video that Mr. Brooks appeared to be under the influence of some type of substance.
Okay.
He appeared to be, had a hard time remembering. I think he made a change in story a couple of times as to how much he had to drink and, in fact, what he was drinking. He might, I think, I'm not 100% sure, but I believe he was confused exactly where he was at, part of Atlanta. I know certain people who may not familiar with Atlanta. You got obviously different parts like any other city, but I think he was confused at some point where exactly he was at, as whether he had gotten food or going to get food. But nevertheless, he, from a prior experience, and as a criminal defense lawyer who handled DUIs, and some law enforcement background, he appears to be under influence or to the point where he probably shouldn't be driving a vehicle.
Mm-hmm.
I think that, that's what I saw.
Mm-hmm.
I'm not saying what I'm saying is gospel truth, but that's what I saw, observed on the video. But the officers decided they was going to arrest him. Things got physical. Obviously, Mr. Brooks was non-compliant and resisting an arrest as such, and he tussled, wrestled with the officers, and it appears to him he got a better hand in both of them. I think he had one flipped up over his back, and he turned him over, and he's basically, I'm assuming he was a pretty strong guy, and he was able to break away, and you see one officer try to use what you call a drive stun on him. That's when the taser, you have two ways that a taser can be utilized. You have a drive stun, which is a pain compliance that's close quarters without actually shooting out the prongs or the cartridge, they would call them in a taser. That's used for pain compliance and such. In that particular area, they shoot a sending electric shock through your body to have you, to subdue you for a period of time so the officer can perform their duty or whatever. You have another one when this taser actually shoot out cartridges at you, prongs, where actually the only way they are effective, and it's very important, hear what I'm telling you. The only way they are effective if those two prongs go inside your body, then they basically send electric current to one another that essentially shuts down your nervous system. That's why you see people taser, they drop. It shuts down their systems. But if only one prong go into you, then it's ineffective. Obviously, if no prongs go into you, it's clearly ineffective. All right, clearly ineffective whatsoever. So that is a point of contention as relates to the use of deadly force at the time. So nevertheless, he breaks away, began to run. I think the video is very evident, clear that the officer takes chase. Both officers, one officer's on the left, one officer on the right. It appears that the officer on the left, closest to him, still was in possession of his taser. And that officer had his taser pointed. Mr. Brooks at some point, appears at some point while he's running, he turns and fired the tasers that he wrestled away from the officer. And from that point, the officer switches over from his hand to his service weapon and fired, I think, 2 or 3 shots, striking and killing Mr. Brooks. So pretty much saw everything what everybody else saw on the video. So
yeah. As to were you able to ascertain or hear where Mr. Brooks was shot, where he actually was shot, where the wounds entered his body at, from the front or the back?
Yeah, Mr. Brooks was shot in his back. If you can look close to the video, it appears that he fired the taser, began to run again, then he was shot. All right, so he wasn't shot as he was firing the taser. You can see a spark come from the taser. Then you can see, then he turns, and he was in the medical examiner actually determined he was shot in the back. So that is a finding of the medical examiner for Fulton County. It's such that said he was shot in the back, and that was a fatal shot, wounds.
So what do you think about that?
Oh man, what I think about it. It's a lot of things to unpack in this particular case. This shooting itself, one, you have 2 officers, okay? You have a fleeing suspect. A lot of people have brought to my attention and want to argue Tennessee versus Garner, Garner versus Tennessee, how do you want to say it? Garner versus Tennessee is a United States Supreme Court case that seemingly, and it actually was a civil case, not a criminal matter, that seemingly gave officers the ability to shoot and kill a fleeing suspect if immediate or imminent danger to the public or the officer was afoot. And you really have to unpack what that means. It doesn't mean that, hey, this person committed a felony, is running, I'm a shooter. You have to be perceived reasonable perception of intimate or immediate threat to the officer's safety or the public. And that gives an officer a justification to utilize deadly force. For example, a bank robber, okay, robs a bank, officers in hot pursuit, he jumps a fence to a daycare. He's armed, he's running towards a daycare. Well, in that situation, one can arguably say that, hey, it was an intimate or immediate threat to the children or the civilians in the daycare, would justify the use of deadly force. And that's what Tennessee Garner kind of read, holding was. But here, when you look at Tennessee versus Garner, okay, and you put all in the totality, and one thing we can always quarterback this thing after hindsight. We can always quarterback and say, hey, well, I would have did this and did this, whatever. But the felony was driving under the influence state of Georgia misdemeanor. All right. Mm-hmm. Bottom line, it's a misdemeanor. The only felony, the dangerous felony or whatever that arose, Johnny, was the felony obstruction of the officers.
Okay, and that's a felony there.
Yeah, based on what you see, fighting was a felony obstruction of the officers. Now, once he shot at the time when he started his flee, okay. Obviously, arguably, at the time when he turned and fired his taser at the officer, or it could rose to the amount of aggravated assault. Okay. Mm-hmm. Because the officer had an intimate danger of fear at the time when he shot the taser. Okay. So you got misdemeanor DUI. Okay. You got felony obstruction with the fighting of the officer. Could have been assault on the officer, battery. I don't know. At that time. Then you have potential aggravated assault at the time when he turned and shot the taser. Okay. So you got to unpack these layers. When you look at that and you say, okay, well, does this arises to what Tennessee Garner referenced, the intimate or immediate danger to the officer and or public? Well, once that taser was fired, it depends on the taser that the city of Atlanta carried. If they carried 2 cartridges, if only 1 cartridge been fired, as such, it seemed like to me that he took the taser that he was previously used on him and he took it out of his hand. But the training, once a taser is fired, shot out, prongs, that taser, especially from a distance, is rendered useless. Okay. So it becomes. You're saying that it only has 1 set of prongs. Well, it depends what taser it is. It can have 2 cartridges or 1 cartridge. I got you. If it's 2 cartridges, you can shoot twice. The prongs. Two shots. Okay. It doesn't have more than, so the prongs are attached to the cartridges, but if you have 2 cartridges, you essentially gonna have 4 of them. Okay. Mm-hmm. So that's you understand that? So you have 2 times you can shoot it. Here's the deal. Once that taser was discharged, and it was only one, the taser had 1 a cartridge in it or whatever, then the taser is really useless. Okay. So the question is, would force being justified at that time? Because here's the thing. He did not have a firearm with a I'm going to say infinite amount of bullets, but a unknown amount of ammunition. Okay, where he can run and shoot somebody. What we know at the time that he had a taser, all right? And once he fired the the taser was, so my understanding that it was rendered useless. That was it. Now, what I said originally and what you have to understand is that you got 2 versus 1.
Mm-hmm.
Okay? 2 versus 1. You got the officer who shot him, and you got his partner. Okay?
Mm-hmm.
So, an argument possibly could be made that justification was afoot if there was one officer.
Okay.
All right? If there's one officer and he had his taser. But when you got, at minimum, let's say he had 2 cartridges still in it. When he shot the first one, at minimum, he only had 1 cartridge left. So you have 2 officers, he only can strike one of them with it. The other officer is going to have free range at it. If he in fact hits the other officer, either to shoot him with his taser or shoot him with his service weapon. So people are trying to justify the shooting as such. Myself as training law enforcement use of force and a lawyer that deals in this area in 1983 civil rights, it's a reason why the city of Atlanta fired him.
Okay.
All right, you know, he was fired.
Mm-hmm.
Because the questions was the force.
Who fired him?
City of Atlanta fired the officer that shot and killed him.
Okay.
He was fired and put the other on administrative leave. Because the question is whether the force was necessary under the circumstances. See, it's 2 things. Use of force, okay, is a term where did you use excessive force?
Mm-hmm.
Okay. Because I can be engaging with you in a tussle, Johnny, and hand-to-hand combat or whatever, and I say, okay, whether the force I use was it excessive, and shoot you.
Mm-hmm.
You understand that?
Yes.
But the question, that's the question as to whether the force was excessive. The force was excessive. You got me?
Yeah, I'm with you.
In this case, the inquiry as to whether the force used was necessary.
So, based off your analysis of excessive force, do we take into account reasonable fear in that particular analysis?
Well, I think that excessive force, you never can have excessive force. It had to be force necessary to accomplish one duty. If that force is necessary to accomplish one duty is deadly force, then deadly force is what it is. So essentially, chokeholds are utilized or usually outside of policies of a use of force in a law enforcement agency. However, if you are in a position where you fear your life, then chokehold what it is. Okay?
Fearing for your life.
Or using a weapon.
Okay. So the gentleman, one has taken off in the scenario that you explained. Does the court take into account the fear that the police officer had, or just the force that he was shown at that time? And the reason why I'm asking that is because I think it appeared that he shot him because he was afraid. I mean, what other reason would he shoot him?
Because he beat him up.
He was mad. Okay.
I mean, because he beat him up.
Well, let's do this.
If you got into a fight with somebody and in the moment they beat you up and you chased them, you know, and you say you want to seek retaliation, revenge, because you got beat up, he got flipped over, he got turned around.
Well, let's do it like this, Attorney Daniels. Let's go back to law school. At the point when Mr. Brooks initially tried to fire the taser, if he had prongs in the taser, would the force be justified to shoot Mr. Brooks?
If the prongs struck the officer, went in it, yes.
Okay. Once he shot and he turns, does the officer have an opportunity to regain that justification?
No. So going back to Tennessee v. Garner, the taser was shot. So here's the rule of law. if you are resisting, okay, and you immediately stop resistance, or you become compliant or so, whatever, force cannot be used. So essentially, if you slap an officer, get on your knees real quick like this, technically they can't slap you back. That's the law. Show restraint. You go get charged, but you can't, now they can't slap you back. One hit, hey, I'm down, I'm on my knees. That is the law. Clearly, I've cited that law, I've argued that those cases as such. But we know human factor in human nature. If somebody slap you, you want to slap them back. Well, if you wear a badge and you swear an oath to uphold the law, if you get slapped and they give up, all right, you can't slap them. If you do, it's murder. If you kill them, it's murder.
Were you, based off the autopsy, were you able to determine exactly where in the back the bullets went?
No, I don't know exactly where the back the bullets entered Mr. Brooks, but I do. You can see from the video that he clearly turned around and started running. So one thing you have to understand that when you have and you know, this is a very close case. All right, I'm not going to sit here and tell you that it's not. Mm-hmm. I think this case is getting a lot of media attention because the environment currently state that we in, and not saying it should get attention. Please don't take that out of context. Sure. Because I think it still shed light that Black males are being subjected to deadly force on site, regardless. And that's why we have the Black Lives Matters and all those things, because the force used is disproportionate for our white counterparts in similar situations. I think I just saw today, somebody put a post where a guy beat up 2 officers, took their nightstick, beat them with it, then took their truck and drove off, and they never put in service weapons. Not one time put in service weapons. Just recently here, individual shot, I think the other day, a couple of days ago, shot at law enforcement. They shot back, he surrendered, and they didn't shoot and kill him. And he was shooting at him. So when you look at that as a race issue, I think this case clearly lays that out, that here we go again, where a Black person is giving a death sentence opposed to their white counterparts when they do something even less egregious or threatening to officers or amongst officers. Does that make sense?
It makes perfect sense. Personally, what I think about, because this past year I've become a little bit more handy with my personal handgun and shotgun, and my initial thoughts were, if he felt as though he had to shoot the gentleman, if those shots are going through the back, could they have been warning shots? Could they have been a shot to the foot? Could there have been a shot to the leg? How do we get 2 deadly shots from the missed taser and just a disregard for all the warning things that could have happened? Because at the end of the day, how many DWIs do you have in Atlanta every night? Who knows, right? I know in small towns we might get 12 in a night. It just, it escalated. There's a DWI, the guy's leaving, but I'm assuming that he has significant training with his weapon. Whereas if he wanted to give a warning shot, or if he wanted to shoot anywhere else, if he shot him, dead in the back, that was a kill shot. I'm not an expert by any means, but you either shooting low or you shooting high, right?
Well, it all comes down to the value of one life that you place on another, as to who you're shooting at as well. And I think it really points to the culture of the police reform that is needed and additional training and accountability that needs to be held for officers who are involved in those type of shootings. And that's what we were talking about earlier. The theory of the law of qualified immunity. And a lot of times when you have an officer involved incident and it may rise to the level of this being egregious or questionable, that the officer user are able to, if they're not prosecuted, a lot of times they're not, they're able to rely on a theory of what we call qualified immunity.
Yeah, let me reboot the crowd just a little bit on that. So guys, earlier this week, the Supreme Court will not rule that they will not re-examine the doctrine that shields police in misconduct suits, which equals to qualified immunity, in which Attorney Daniels was speaking about. So we're segueing from talking about when he gets these cases, when somebody's sitting across because one of their family members are no longer here, is he able to go in and actually sue them at that time? And Attorney Daniels, please school us on what the effect of this decision is.
Well, the effect is that the Supreme Court hand down fantastic news for violent police officers. That's the effect of it. Simply put, from the layman's standpoint, that the officer who engages in acts that are a violation, seemingly a violation of person's civil rights. And let me just kind of, I mean, when people always ask me, well, what does that mean, violation of my civil rights? Well, particularly, probably the most strongest right that you have is being secure of your body. All right, home, car, and body from excessive seizure. From a seizure, and a seizure is the law has identified seizures as being a kind of lost you, Johnny.
Oh, you're fine. You're fine. Continue.
All right, seizures of being of your person. So if you shot or beaten, tasered, or any capacity, that they consider that to be a seizure of your body. And a lot of times in this situation, and going back to the Brooks situation, the lawyers have to determine to be successful, have to establish to be successful that the officer involved, one was placed on notice this act was a violation of Mr. Brooks' Fourth Amendment. I think that's obviously, it's clearly established at the time. Then you have to prove that a violation took place. Well, the officer was clearly operating within his discretion scope of an Atlanta Police Department, police officer. So therefore, the doctrine of qualified immunity is invoked.
Okay.
All right.
Okay.
It has to, the person have to be operating in the scope or their discretionary capacity. Mm-hmm. Of their job, and we're talking about a person operating under what we call a color of state, a color of law, the authority of a government entity. And we might have talked about this before. So you have to have that first in order for qualified immunity to come into play. If that person is not operating under that brand, and I had a case against a civil Atlanta police officer where I had to successfully argue to the courts that, hey, this guy is off duty, moonlighting for a private entity. He is not operating his capacity. Although he got a uniform on, he is off duty. He's basically working for a private entity. Mm-hmm. Therefore, the doctrine of qualified immunity is not applicable. And in fact, I cannot even sue him under the doctrine of 1983 lawsuit that gives citizens rights to sue where their rights have been abridged by a person or violated by a person who's operating under a color of state law, such as a law enforcement officer. So this individual this case I had, he was not even operating in the capacity of a Atlanta City police officer. So therefore, I was not even suing him under 1983, okay? That even made that qualified immunity applicable, not just the application of 1983. He was not operating in his scope of a Atlanta City Police Department. So first thing first, and I'm talking to the citizens out there, people's listening, but right now I'm also talking to the lawyers, all right? When you get a case and the person's not operating under a color of state, even if they got a badge, then your claim is not really based on a 1983 claim. You have to really examine it to see, can you really pull that? And if you're not bringing a claim on a 1983, when the defense assert qualified immunity, that is your trigger. Like, hey, we're not even talking about that they're operating their official capacity or under a color of law or state. So for qualified immunity to start, the person has to be operating under state law, whatever badge. Next, you have to go through analysis. All right? It's analysis. Was the right clearly established at the time? All right? So levels. First step, was a person operating under a color of state law, ordinance, city, whatever, county? Was they cloaked with that, operating under that authority? If your answer is yes, you go to 2. 2 is, was the right clearly established at the time? All right? And if you're talking about a seizure of one person's body, violation, Fourth Amendment, it's plenty of case law that's going to establish, and the answer more likely is going to be yes. The next question is, was that right violated? All right? If that right was violated, okay, then it's a question as whether that person is entitled to qualified immunity. Intentionally, knowingly violates that person's rights. Are they entitled to qualified immunity? Then that becomes a question for the jury.
Yes, sir.
So a lot of times the qualified immunity is asserted at the what we call summary judgment stage. And John, if you want to tell somebody what summary judgment is, feel free to do so.
You got it. So
summary judgment usually at the close of discovery, once you have exchanged documents and your depositions and things of that capacity, then usually the defendant, but sometimes the plaintiff also moves summary judgment, and basically saying there's no genuine issue of fact. There's no disputed fact that allows a jury to answer this question. One, if we're talking about a defendant's position in a case like this, saying that you have no evidence to show that the officer was not acting reasonable at the time. All right? There's nobody saying that the officer acted reasonable. You're the person who was shot and killed, Kane said, says nobody said it was not reasonable. Usually how you overcome those.
George Floyd comes to mind.
Right. So, in George Floyd, let's examine the George Floyd case when it comes to a potential question of summary judgment. I don't think you'll get there. Let's say you do.
Okay.
The question is, was the officer acting reasonable at the time that he placed his neck on George Floyd, placed his knee on George Floyd's neck that ultimately led to Mr. Floyd's death? So once you examine it, remember you got to do this. Was the officer operating in his capacity at the time as a law enforcement officer for the city of Minneapolis? Yes. Was the right clearly established at the time that one cannot be subjected to, here's where it at this time, excessive use of force. All right? You can use force for one to accomplish one's duty, but you cannot use excessive use of force. George Floyd case is not a force case. All right? George Floyd case is a case of excessive use of force. The D on the neck. All right?
Yes, sir.
So if George Floyd was face down in a prone position, the knee not on the neck, all right, Johnny, and he died, then the question, was the officer violating Mr. Floyd's Fourth Amendment right as such. And the argument like, no, he just had him in a prone position, and he succumbed to to something. But when you look at the facts as presented in this case, he had his knee on his neck for 8 minutes and 46 seconds, even after George Floyd became unresponsive. All right. So the question is, and no stretch of imagination that he was justified to put his knee on his neck at all. But let's say that the officer was not placed on notice that a knee on neck is a violation of the Fourth Amendment excessive use of force, because this is something that they use in practice in the Minneapolis Police Department. Okay. However, once Mr. Floyd become unresponsive and his body goes limp, the question is that force still what? Necessary. All right. You see how a lot of these things you got to really unpack in different layers to really get to those arguments. So when you're talking about qualified immunity relates to Mr. Floyd, one, the officer clearly was operating his function as a law enforcement officer. Two, the right is clearly established that excessive force is not warranted to violate the person's Fourth Amendment right. Three, was the force was the right violated? I think the video evidence is clearly dispositive as it relates to whether the right was violated, and I think some experts can really lay that out as well. That this is a forced police tactic or maneuver that is not widely used, or in some cases illegal use. But even to the extent that the Minneapolis Police Department say determine, or the officer argue, say, well, this is a ploy that we've used in the past. Okay, even if you was not placed on notice, it's something that you could not do per your policy, per your departmental policies or procedures. When Mr. Floyd was no longer responsive, not moving, you should have been placed on notice that the force that you were using at that time was at minimum excessive. So I think there's not going to be an issue with the George Floyd matter. I think it's going to be a point of contention with the Mr. Brooks matter, because Mr. Brooks, in fact, fired the taser. The qualified immunity doctrine is not there to, a lot of people say it protects all but the clearly incompetent. I think an argument could, in fact, be made that the officer was justified from what he knew at the time of discharging his weapon. In the context of talking about qualified immunity as such element, and whether a civil liability will flow to the individual officer. You have to understand on these cases, when we're talking about qualified immunity, and this is a note that I hope people understand, qualified immunity does not apply to the city. Okay. Right? No respondent superior under 1983. No vicarious liability. So it's not like if you get stopped by accused of shoplifting at Walmart and they illegally detain you for a period of time, it's not imputed. The liability is not imputed upon Walmart based on the acts of their agent, right, or their servant, as such. The acts are imputed upon Walmart based on the acts of their agent or servant. I think I said it backwards. Under 1983, in these type of officer-involved cases, then the Act 1983 only hooks or makes bring in the umbrella of liability to an active tortfeasor, meaning that the officer who's involved is considered the active tortfeasor, and you cannot impugn liability to the city of Atlanta for the acts of the officer. So essentially, the city of Atlanta can say, well, we fired him. We're not going to represent him. You get a $10 million verdict. We don't care. We ain't going to pay it. You know that, right?
Wow.
So they say we're not responsible. One reason they don't have to pay it, because the city of Atlanta, with its billions of dollars budget, do not carry insurance for their officers for misconduct and criminal acts. That's another discussion to have.
We definitely will get to that. right now we're having a lot of conversations over the past couple of weeks since I spoke with you. Obviously, you're in Atlanta right now. How is the lay of the land? Is it still pretty much?
Oh,
And it was around June 16, 2020. So we're a couple of days out. Mr. Brooks was just shot this past Friday, so this will be on Tuesday. And I'm asking you how
obviously it was some, and I'm sure you can see in the news that the Wendy's that was where Mr. Brooks was shot at was burned. I guess the record and evidence came out that somebody at the Wendy's, in fact, called the police on Mr. Brooks, and they burned the protesters, demonstrators, or you want to call them. They blocked the fire trucks from getting in. They blocked law enforcement from getting in, and they burned the Wendy's down. Yesterday, I was downtown Atlanta taking a stroll, walking around my downtown, and I saw a lot of demonstrators meeting at the state capitol. I think it was several thousands, maybe be too much in that word several, but I know it was thousands of protesters there. They was peacefully demonstrating. I saw a lot of non-blacks carrying Black Lives Matters and signs and talk about defunding the police, which doesn't mean taking police money, by the way. I think a lot of people got that misconstrued what that actually means. And the culture now, I guess the environment now is the city is coupled with the coronavirus pandemic, that the city is, you can feel the tension in the air, that when it comes to blue and black, that it is a clear line of demarcation.
Yeah.
And I know that a lot of people who are people of color, blacks or whatever, who wear a uniform, are conflicted at times, because no matter if you wear a uniform or not, that you black first, and you're not using that as a ploy to pick a size or such. But at the end of the day, when black men who you can relate with and look like, and share the same cultures, are getting gunned down at a disproportionate rate for a incident that should have never happened. Because let me just say this, when you look at the grand scheme of this thing, Johnny, as it relates to Mr. Brooks, everything that I said about qualified immunity, possible officer justification, being shot in the back, this should have never happened.
Yeah.
This should never happen. And I'm not saying that, Mr. Brooks is, obviously Mr. Brooks should have not, we're not oblivious to the fact that Mr. Brooks, we wish Mr. Brooks would have complied and put his hand behind his back, considering what happened, the alternative. Mm-hmm. I think nobody would say, hey, well, I'm glad he rebelled and, he's a martyr, if they are, they're crazy. Because one would like longevity, one would like to live.
Yeah.
But when you look at it as a whole, in the totality of it all, Mr. Brooks was still shot and killed, even if the officer is deemed justifiable under federal and or Georgia state law. I mean, one cannot remove the fact that the officer pulled the trigger and shot and killed him when he was running in the back. So in Atlanta, I mean, I don't know as the applicability as it applies to foot chases, but I know in car chases, Atlanta have a no chase policy.
Yeah.
No chase policy whatsoever.
The human side of me, not the law side of me, just really, as you said, relates to, in light of everything, it's a DWI, right? We know everything is, when those guys put that uniform on, they knew that this was a extra volatile environment right now. Like, when you see this particular incident and you're like, how are we so tense right now in our environment and this happens?
Well,
in the back of your mind, it's like, hey, you know what, again, like I said, we have the coronavirus going on, so we're probably not stopping as many people as we normally are.
Right.
Mr. Brooks obviously was intoxicated at this point. It comes to a wrestle, it's thought to just go ahead and let him go.
Right. I mean, yeah. It's crazy if he would probably told him.
That's where I am after 90 days of lockdown, the coronavirus, after Ahmaud Arbery, after George Floyd. This is just where I am, and I'm not a law enforcement officer, and I'm sure those guys did what they thought were best. But at this point, we got to do things a little bit more differently. Like, how does this happen the next week? And that's just me being frustrated and emotional about it. One thing I will say is that on a brighter note, Attorney Daniels, I know you're a big basketball fan. Your Atlanta Hawks are killing it, I think, for the last couple of years or the last decade or so. Mr. Kyrie Irving came out as one of the chief execs of the NBA Players Association and says that, in light of the protests, that he thinks that the NBA should not go back on the short season because he thinks it will take media attention away from the protests if they do go back. And then there's a gentleman by the name of Mr. LeBron James that, from what I hear, is not too happy about that. And he wants to go back and he wants to play. Not so much on Kyrie or LeBron, but do you have any thoughts about whether the NBA will have an impact on protests negatively or positively?
Well, it's funny you asked me that because I actually had an opportunity to talk to
Kyrie Irving.
Well, not Kyrie Irving, but I had an opportunity to talk to a personal, somebody who I know, a friend who is an NBA superstar.
Oh yeah.
I'm not gonna mention his name.
Yeah, we know. It's like that.
He's very well known.
We know the drip is like.
And I asked him, how do you feel about it? He was like, I don't think we should play. Exactly the position that Kyrie Irving took, and I jokingly mentioned to him, and he's a current NBA superstar. I'm not gonna tell you what team because I'm not gonna put him out there like that. I basically joking with him like, hey, LeBron want to get out there and get that trophy because y'all know y'all boys are gonna be able to stop him. Of course, he laughed about it, but he probably know I'm true. Telling the truth. I ain't care. It's funny to me. But yeah, he was in a position, and his state of mind was just like Kyrie Irving's. And actually, he's been involved with some activism himself that he felt like we are in a battle for our souls in the country.
Mm-hmm.
Basketball should always take a back seat to that.
Mm-hmm.
We are in a position where NBA superstars, where we should be out vocally and taking a stance and supporting or showing, hey, that we are also unified as well. Black Lives Matter as such. In that capacity, and not concerned about getting a superficial trophy that really is going to have an asterisk beside the season because we're not a full season. And quite frankly, I mean, I'm not missing basketball, not missing baseball, and that may be surprising to a lot of people, but we are in a battle for our country now. During the World War II, baseball was suspended. They had to have female baseball leagues because they knew at the time we were at war. We may not be at a physical war, but we are in a war internally. This is a war that good has to prevail.
Yeah.
And good is not black. Good is not a white. Good is not what. It's not a race. Good is that the human race prevail. Johnny, people are dying of COVID-19 daily. All right, daily. Infections are on the rise because people have forgot that we have a silent killer afoot in our world. But we also have a visible killer. Yeah. And a killer of black males unjustifiably across our nation. So I agree with Kyrie. I agree with my friend. I appreciate LeBron James for who he is and what he's done. But I would ask Mr. James, if I could speak to him personally, hey, brother, this ain't the time. This is not the time. You know, this is the time where if you was ever needed before, with your influence and your resources, this is the time. Because the country is crying out, not for who's going to hoist the NBA trophy at the end of the year, or are we going to hoist righteousness when it's all said and done? The United States is under indictment for its past crimes and transgression. It's under indictment, presently at state. And I can care less about sports. I really, really can. And I agree with the ball players who care less about it too. And that's their livelihood. They don't care. I don't care either. You know? I mean, that's how I feel about it.
And it's so interesting. And as I said, experts only, real conversations. And it's been frustrating all week. You touched on it earlier. The phrase "defund the police" has been on headlines, and it really frustrates me when I know learned people who know what that phrase means attempt to fool the masses and make it seem like it's a literal statement. Attorney Daniels, could you educate Northeastern North Carolina and the YouTube channel? You guys make sure you keep liking and getting Attorney Harry Daniels, Civil Rights Attorney Harry Daniels, to come back on what exactly defunding the police means.
It's basically a rebooting, recharge to address issues or points that needs to be channeled in policing. Nobody is going to take anything from the police department so they can do their job. And obviously, I want the police there. You want the police there as such to protect and serve. But you talk about resources and allocation of resources in order to promote the current climate of what is needed. So instead of buying militarized equipment or tanks to drive down mainstream or North Carolina, we need to focus on training and skills and things that capacity, de-escalation tactics as such, because we have enough of those at this point. So when you talk about defunding, you talk about a shifting of funds towards the law enforcement agency. Is that what your understanding is of it?
It is, and and obviously in criminal defense, I see the law and order. I see the funding going to, what you would think of law and order in the olden days, and it would be so easy for someone to get that concept. But if a particular media is leading people to believe it's one thing, and then you see it again, I'm bringing Attorney Harry Daniels down here to tell you guys and explain to him exactly what these terms mean, so that when you are having these conversations, stop your friend who's talking ignorant, go to my YouTube channel, tell him you need to listen to Attorney Harry Daniels. He can tell you what it's all about. I really appreciate you today. We've had so much happen in the past couple of weeks since I've talked to you. I appreciate your time. I love you, brother. Be safe down there in Atlanta. We're going to go ahead and get out of here. Again, like and subscribe. Any questions that you have for Attorney Daniels, we're going to have him come back on his own series called This Ain't It. Attorney Harry Daniels, This Ain't It. I appreciate you, brother. Be good.
Hey, man. Take care.